Good afternoon, ladies and gentlemen. The Government Operations Committee for Monday, February 26, 2024 will come to order, please. Clerk, please call the roll.
Representatives Bulso, Carr, Chisholm, Clemens, Crawford, Eldridge, Faison, Hakeem, Helton Haynes, Himmer, Johnson, Jones, Kiesling, Kumar, Lafferty, Littleton, Martin, McCalman, Vice Chairman Reedy, Chairman Reagan.
Here.
Mr. Chairman, you have a quorum.
Thank you, members. Do we have personal orders? Seeing none, we'll go ahead and get started on our calendar. Item number 1 is House Bill 1191 by Chairman Williams. We have a motion and a second. Chairman Williams, you are recognized, and I'm showing your bill with an amendment on it. That's
Yes, sir.
12326, is that correct?
Yes, sir.
It's traveling with it. We don't need to have it. Okay. You're recognized for an explanation of your bill as amended, sir.
Thank you, Chairman and members. This legislation is focused on addressing factors that involve our public charter schools. Charter schools in Tennessee do not receive local capital dollars for their facilities and must instead use operating dollars, state and local, to meet their facilities needs. There are school buildings that are vacant and underutilized across the state, but often access to these buildings are extremely difficult, if not impossible, to utilize. Instead, charter schools in Tennessee must finance, locate, build, update, or renovate their facilities to use those old school buildings. This bill makes several changes, 2 different sections. It proposes a more explicit definition of what vacant and underutilized facilities are and allows charter schools to petition the Comptroller's office to help manage a list of what those vacant facilities may be. It allows charter schools to access vacant or underutilized facilities at or below the fair market value. That fair market value is determined based upon 2 independent appraisals of those, and the fair market value is assessed as an average of those 2. It also requires LEAs with charter schools to publicly report on the capacity and use of their buildings, so there's more transparency around how buildings in the district, including buildings occupied by charter schools, are being used. It also reiterates that charter schools are public schools and are subject to the same tax exemption as our public schools receive. Finally, it requires LEAs in which at least one charter school operates to give charter schools the first right of refusal to lease or purchase a facility either at or below its fair market value, which I described earlier. A vacant or underutilized building will be identified in the district using that Comptroller's report. I'm happy to answer any questions the members might have.
Members, do we have questions of our bill? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. This legislation, I think, first came before us last year, and it has not gotten any better. So what we're saying is to a public school system is that if you have property that you own, you're using for storage or for any other purpose, for future planning purposes, they probably want to use it for a school. They just don't have the funding from the state of Tennessee to actually fit it for a school. Now they have no choice but to sell it to a charter school operator, which is a private entity, at or below market value, fair market value, that is partially decided by that public charter, that charter school, or lease it to them at or below fair market value, based on a value partially set by that public charter school.
Sponsor, you're recognized.
Thank you. That's a great story, but that's not what this bill does. In fact, what this bill does is it brings transparency to the process, because your description said these were storage buildings. If it's deemed storage, it is a utilized building. This is for vacant or underutilized buildings, not vacant, not storage buildings as you described.
I'm sorry, follow up.
Yeah, well, the definition of underutilized property includes buildings that are using it for storage of any kind.
Mm-hmm.
So I think storage is, but that's beside the point. Let's get to the point here is the money. Where all this goes back to is the money. Now, LEAs, which are operating on too few resources and too little money, that have property, that property is generally the property of the LEA. This bill would give them no decision-making authority whatsoever, backing them into a corner where they've either got to sell that property at or below fair market value, or they've got to lease it at or below fair market value just to a charter school. They have no option in this equation. And that public charter school, which is inherently a conflict of interest, is helping set that fair market value. How do you justify this from a fiscal standpoint?
You're recognized, sir.
Thank you. Once again, it's a great story. But it doesn't apply to this bill. What this bill does, it sets a fair market value between both parties. And as you may know, Chairman, those facilities that are underutilized or vacant, those facilities are paid for by the taxpayer, the same taxpayer that's paying for both public and charter public schools.
Thank you. Representative Johnson, you're recognized.
Thank you, Mr. Chairman. Well, in Knoxville, the situation, if they would get first right of refusal, we have a lot of nonprofits that work in conjunction with our county schools, and they might provide after-school care or community school things. And really, those are the folks we want having those buildings, the ones that are working in conjunction with our public schools. And so you're telling me, is it correct that you're saying that charter schools would get the option before they would?
You're recognized, sir.
By the nature of a first right of refusal, that means they get the first right to refuse it or to purchase it or to lease it. However, if the LEA or the county, because it may be a county or city owned property that's currently not a school, but if they chose to do that in the fair market value, they just get a first right to purchase it. It doesn't mean they have to sell it to them. That's the nature of a first right of a refusal. They just get the opportunity to say no.
Follow up.
Well, I think part of the problem here is what we know about the agenda there, but also what I saw in the bill was that if there were major renovations that needed to be made, the LEA would be responsible. The regular upkeep is done by the charter school, but they said any major things that have to be done would be the responsibility of the LEA.
You recognize, sponsor.
I'm not quite sure who they is, but in the bill, it says that if it's operational expenses, like you said, those operational expenses are paid by the charter school.
Mhm.
If there are improvements that need to be made to the facility and they choose to exercise the first right and purchase it, then the charter school would be responsible for those improvements. As you probably know, the governor included $15 million for public charter schools for those improvements in a grant fund this year. Additionally, I will say, if the charter school chooses to lease the facility, then the fair market value would be determined based upon what the cost of improvements are and the base price of the lease, much like any commercial property would be for a shell and tenant improvements. But those costs would be paid for by the charter because those improvements would be financed in the lease agreement.
Next on my list is Representative Martin.
Thank you, Chairman Williams, for this bill. Just a clarification, an LEA maintains control of the building if they're utilizing it. Is that correct?
If the LEA owns the building and they lease it, they maintain control of the building. If the LEA or the county or city government owns that building and a first right of refusal is exercised, then that property would transfer ownership to the LEA. If the LEA if the charter school then in turn, after it's made all of its improvements and they choose to go and build another school and go somewhere else, then the same formulary that was used to purchase the school before would be used to do that again based upon the fair market value of two independent appraisals.
Follow up, sir.
The thing that I just want clarity of is that the LEA is not being forced to sell this. They're not being forced to lease this. This is if they put it up for lease or if they put it up for sale, that the charter school gets the first right of refusal. But up and until that time, if the LEA is using this school, they have the right to use it as they have been. Is that a true statement?
That's
Sponsor, you
true.
recognized.
That's all I need.
Next on the list is Representative Hakeem.
Thank you, Mr. Chairman. Representative Williams, when we talk about fair market value and the appraisals, when I say who would do the appraisals, is this something that would be done by the LEA, by the charter school, or who would facilitate that?
You recognize, sir?
Thank you for the question. Would be the LEA or the entity who owns that building, because we keep saying LEAs, but there may be an instance where it be a vacant or underutilized property that's owned by the county. The LEA or the county or the city that owns that property would be responsible for their own appraisal of fair market value. And then the charter school would be responsible for the other appraisal.
Follow up.
Thank you, Mr. Chairman.
Representative Hemmer, you're on my list.
Thank you, Mr. Chairman. I had a situation in my district I was hoping to get a little clarity from because I'm talking with the department and the board is it's a little bit hard to tell. But I got a situation where I had a school that was basically just moved out because a new school was built. However, our LEA is going to be using that for kind of flex space for other schools that are getting remodeled essentially. So how, in a situation like that, how or when would my school be put on this list?
You recognize, sir?
Thank you. It would be based upon the utilization of that property. If they had a plan for that property, for instance, in the instance that you just described, my understanding of the bill and the current statute, because this is an amendment to the current statute, would be that because they have a utilizational purpose for that in the short term for those students, that it would not be listed as underutilized or vacant.
Follow up. Representative Jones, you recognize?
Thank you, Mr. Chair. We got emails this morning from a lobbyist saying that if we don't vote for this, it will be reflected poorly on a scorecard that's coming out. So I just want to put that in transparency. I know this is going to pass, but I was wondering if the sponsor will be open to an amendment. I would like to make an amendment to name this bill the Hedge Fund Real Estate Discount Support Act. Would you be open to that?
Representative Jones, the amendments that are put on a committee must be filed in written form. You have not made such an amendment, so it's out of order. Follow up, sir?
I plan to make the amendment on the House floor, but I just want to see if the sponsor will be open to that so we have transparency. This is a Hedge Fund Real Estate Financial Support Act. Would you be open to that name so we can be clear to the taxpayer and to Tennesseans about what this bill is really about? Would you be open to that, Representative Williams?
Representative Williams, you recognize?
Sorry, but it doesn't apply to this bill. Thank you.
Representative McCalman, you recognize?
Thank you, Chairman. Move previous question.
Previous question has been called. Is there objection? Seeing none, we have a motion and a second already on the floor for approval. Any discussion of the motion? Seeing none, all in favor indicate by saying aye. Aye. All opposed, nay.
No.
Ayes have it. If you wish to be recorded as a no, indicate so to the clerk. Next on our agenda is House Bill 1695 by Representative Alexander.
Second.
We have a motion and a second. You are recognized for an explanation of your bill, and as I'm showing you already have an amendment on it. House State Government Amendment 13524, which is traveling with it. Is that correct?
That is correct.
Okay, we don't need to adopt that, but it does rewrite the bill.
That
You
is
are
correct.
recognized for explanation of your bill as amended.
Thank you, Chairman. Thank you, committee. This is a bill that you've heard before on the House floor during special session. It is the autopsy, what we call the autopsy bill, and here's what it does.
Just
it-
a minute, Representative Alexander. The chair made a mistake. When I had gavelled it approved, I forgot to say where it goes. The previous bill goes to Finance, Ways and Means. Sorry. Now you're recognized.
Okay. What this bill does, it just means that the reports of county medical examiners and autopsy reports of minors whose manner of death is listed as homicide are no longer they're no longer public documents. The report of county medical examiner or autopsy report of a minor whose manner of death is listed as homicide may be released for three different ways. The minor's parent or legal guardian is not suspect in the circumstances of the minor's death, and the parent or the legal guardian consents to the release. Second, if a court orders the release of the report showing a good cause. And third, if another state or a federal law requires such a release. And that is my bill.
Members, you've heard an explanation. I have Representative Hakeem is first on my list.
Thank you, Mr. Chairman. Representative Alexander, it's just maybe a point of clarity that I'm seeking. If police are investigating, we'll say a homicide, a potential crime, does this inhibit them from, in a timely manner, getting access to this autopsy?
Absolutely not.
Thank you.
Representative, pardon me, Chair Lady Littleton, you're recognized. Can I ask you to withdraw that? We do have people on the list to speak on it. Would you mind? We have some witnesses to speak. Thank you. Motion is withdrawn. If there are no other committee members to address the bill, in that case, I have on my list a Ms. Deborah Fisher. Is Ms. Fisher present? Would you care to come forward? We have to go outside. We will. We are out of session. Please make sure your microphone is on. Give us your name.
Chairman, I'm Deborah Fisher and Executive Director of Tennessee Coalition for Open Government. And I actually, when I signed the card, said I'm available to speak if there are questions. So I'm happy to do that.
Okay, my list is that you wanted to speak. Okay.
Oh, yeah, but I'm happy. We're opposed to the bill, as I mentioned on the card, for reasons that it could hide criminal information related to deaths of children in DCS custody or as a result of law enforcement, and prevents access in other situations. Not knowing what's in the report, it's hard to go to court to show good cause. So that's all I'll say. If there are any questions, I'm happy to answer.
Members, do we have questions of our guests? Representative Johnson, you're recognized.
Thank you. I'm thinking of I'm thinking of a couple of DCS cases. I'm also thinking of a case not so far away in Williamson County, and I'm wondering if, if you could explain a little bit more about how that could cause a problem with investigating those types of homicides for
You're
children.
recognized.
Thank you. Right. So the legal guardian in the DCS case would be DCS. And so if someone is in foster care or in a facility, the legal guardian, DCS, the government, would have to agree to the release of the autopsy report and the information in it. And the information in it is, in some deaths, the information can help identify who the perpetrator is, because it can give details about how the minor, the child, died. And so the concern is that, there's never, or the bill sort of, in my view, assumes that nobody ever makes a mistake, that law enforcement always does everything absolutely right, and no one's ever trying to cover up the cause of death. And I think probably most of the time that is true, right? But sometimes it's not true. And we have examples of when others, independent people, sometimes journalists hired by, or not hired, but journalists working with extended family members who are not the parents, were able to get an autopsy report. There was one in Columbia where they were able to use the autopsy report, get a medical person to look at it, and convince the DA in Columbia to reopen the case again. And the mother's boyfriend was found guilty in that child's death. So I know that this bill is, has a very emotional component. I get that. I understand it for sure. But we just think that it needed better avenues for getting access in those situations, particularly when it involves the government, a child dying in government custody. I really think that most of us can agree that that's really important. And then also situations where there's not an obvious parents are missing, or that kind of thing. So.
Follow up.
Yes, just really quickly. Do you see a way that this bill could be written so that it could address the situations that we're talking about, as opposed to those DCS and other type situations?
You recognized.
Yes, I do.
Could you expand on that? The question is, I know it was yes or no, but
Oh,
when she says, do you see a way, do you have suggestions?
I do have suggestions on creating another reason under the unless list that involves DCS and law enforcement situations and interaction. And then an avenue where you could actually, inspect the record, if not get a copy, which I feel like, but I mean, this is of course for, I think one of the concerns is that there would be copies out there floating on the internet. And in fact, I think that in this situation, though I've not seen it, that may be the case in the Covenant shooting.
Thank you. Follow up. Do we have other questions of our witness? Seeing none, we're going back into session. Thank you very much. You're excused.
Thank you, Chairman.
We're back on the bill, and Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman.
Oh,
I
wait,
call for
I'm
previous
sorry.
question.
The sponsor would like to respond.
I'm sorry,
I'm sorry.
I just
Sponsor,
wanted-
you're recognized for response.
Thank you, Chairman and committee. I just wanted the committee to know that Ms. Fisher's testimony is inaccurate. Actually, the amendment on this bill was from DCS, and that was included in the language that says the state or federal law requires such a release that let DCS in. That gave them permission to investigate.
Thank you. Now, I'm sorry, Chair Lady Littleton, I do apologize. You're recognized.
Thank you, Mr. Chairman. Maybe 3 times will be a charm this time. I'll call for previous question.
The question has been called. Are there objections? I need to see 3 hands if there's going to be objections. I don't see it. So we're voting on the bill. All in favor indicate by saying aye. Aye. All opposed, nay. Ayes have it. Bill moves out to calendar and rules. Thank you.
Thank you, Chairman. Thank you, committee.
Members, we're on item number 3 now, House Bill 1826. We have a motion and a second for positive approval, and Representative Martin, you are recognized.
Yes, sir. And there is amendment traveling with the bill. As long as you
I
have
show your
those.
amendment as 13686, and it's already on the bill. Is that correct?
That is correct.
All right, we don't need to approve it here. Go ahead. You're recognized
deal.
on your bill as amended.
Thank you, Chairman and Committee. I am pleased and honored to be carrying this piece of legislation. As a healthcare provider, it's a kind of good healthcare policy I believe can benefit our most vulnerable in Tennessee, which is our chronically ill children. This bill is ethically and morally sound for parents. It's fast and effective for the children, and it's a massive cost savings over the long haul for our state insurance plans. This will make possible the use of rapid whole genome sequencing for chronically ill children in the NICU and PICU in Tennessee. This type of testing, which is typically used in the first year of life, will help provide quick and definitive answers for families and the providers. This testing can identify genetic variants associated with rare disease and help the providers diagnose this condition quicker. The savings is built into this process. Currently, these chronically ill children can stay up to 18 months in our NICU and PICU environments while attempting to find the diagnosis. So with the use of RWGS, we will be able to have a definitive diagnosis within 7 to 10 days. So for the cost from an MRI, this will help get the most vulnerable kids out of the NICU and then on a clear path towards their health. This similar bill passed last year in the state of Florida after their pilot study showed 2.4 million saved to their Medicaid plan statewide. So
Members, I'm sorry.
No, you're good.
Members, you've heard an explanation. Do we have questions of our sponsor? Seeing none, we have I'm sorry, Representative Hakeem, you're recognized.
Thank you, Mr. Chairman. Your study of this, does it have any impact on families? I guess to have this done and to be turned down, we'll say, by an insurance company or something of that nature. A child that young,
Absolutely.
they can't get insurance.
If
on
they
these.
couldn't
You're,
get it.
you're recognized, sir.
Are you asking what would that be to the family or if that's currently happening?
Clarification?
Is it more likely to happen if we go forward with this bill?
I got you. Yes, sir. Yes,
You're
sir.
recognized, sir.
Oh, thank you. Yes, sir. If this bill were to pass, then more likely that opportunity be allowed for those children if it was covered. So,
Follow up.
Yeah, what I'm trying to get at is the ability of insurance companies to disallow
okay.
children or families because they know this is a pre-existing condition.
You're recognized, sir.
Thank you, sir. Currently, it's not covered. So I'm not positive on that outcome of that aspect of it.
All right. Additional follow-up?
No, thank you.
Do we have other questions of our sponsor? Seeing none, without objection, we're voting on House Bill 1826. We have a motion for a positive recommendation. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out to Finance, Ways and Means. Next on our agenda is House Bill 2828 by Representative Camper. Leader Camper, you're recognized. We have a motion and a second for positive recommendation.
Thank you, Mr. Chairman and committee. Mr. Chairman, committee, this bill establishes the African American Cultural and Historical Grant Fund to be administered by the Tennessee Historical Commission. The purpose of the fund is to support capital projects at facilities in the state that highlight the contributions, culture, and history of African Americans. Money in the fund may also be used by the Historical Commission for program administration, for marketing expenses, program evaluation. However, such expenses may not exceed 5% of the total amount appropriated in any fiscal year. Subject to the availability of funds, the commission shall allocate and disperse grants to the entities and facilities to effectuate this bill. The commission must establish and publish guidelines for the applications, including eligibility and the awarding of grants. However, priority for the grants must be given to projects that encourage the design or construction of a new facility to the renovations of existing facilities in the area with the greatest cultural significance in which no facility exists. Enhance the beauty or aesthetics named for significant African Americans, to restore the facility and facilities on the National Registry of Historical Places. This bill has to provide annual report to Finance, Ways and Means every year by March 1st and every year subsequent to that, both at the House and the Senate. And with that, Mr. Chairman, I'll take any question.
Members, you've heard an explanation of the bill. Do we have questions of our sponsor? Seeing none, any objection to the question? We have a motion on the floor for a positive recommendation. Any discussion on the motion? Seeing none, we are voting on sending this bill to Finance, Ways and Means. All in favor indicate by saying aye.
Aye.
All opposed, nay. Bill moves out to Finance, Ways and Means. Thank you.
Thank you, Mr. Chairman and committee.
All right, members, we're going to go out of order on the next item. We're going to skip to item number 8 by Representative Faison. We have a motion and a second. Representative Faison, you're recognized.
Thank you, Mr. Chair. Which bill number are we on? I don't have that calendar in front of me.
1862. Sorry.
1862. Thank you, Mr. Chair. This is a compact for physician assistants.
You want to go any further in that? Members, do we have
Gives-
questions?
Nope, it's travel.
The amendment is traveling with the amendment. Members, do we have questions of the sponsor on the bill? By the way, for those in the audience that may not know what a compact is, an interstate compact is an agreement among states for recognition, for example, in this case, of reciprocity of licensure and credentials. In this case, we're talking about physicians' assistants. We already have multiple compacts in place in our state for nurses and doctors and other professionals. This is adding to that list. Any questions now of the sponsor? Dr. Kumar, you're recognized.
Thank you, Mr. Chairman. I think it's a very good idea. Thank you.
Question on the bill.
The question's been called. Do we have any objections? Seeing none, we're voting on House Bill 1862. All in favor of positive recommendation indicate by saying aye.
Aye.
All opposed, nay. Bill moves out. Finance, Ways and Means. Representative Faison, you are recognized on House Bill 1863.
Motion.
We have a motion and a second. And is it, I show an amendment traveling with it. Is that correct, sir?
Yes, sir.
And it's already on it, correct?
Yes, sir.
The amendment is 13319, correct? All right.
That's correct.
You're recognized for an explanation of your bill.
Thank you, Mr. Chair. This is like the PAs. This is for a dietitian's licensure compact.
Members, you've heard the explanation of the bill. Do we have questions of the sponsor? The question's been called on the bill. Do we have any objections? If not, we're voting on sending House Bill 1863 to Finance, Ways and Means. All in favor indicate by saying aye. All opposed, nay. Ayes have it. And I will now pass the gavel to Vice Chair Reedy.
Thank you, Mr. Chairman and committee members. We're back on item number 5 on the calendar, House Bill 1375. We've got a motion and a second. Mr. Chairman, do we need to go ahead and put your amendment on at this time?
Yes, it has to be put on, sir. That's amendment number 13773.
We've got a motion and a second on the amendment. All in favor of putting amendment 13773 onto House Bill 1375, signify by saying aye. Opposition, nay. Amendment goes on. Chairman Reagan, you are recognized on the bill as amended.
Thank you, Mr. Chair. The amendment just changes the effective date that the commission will be vacated and the dates for staggered terms. What this bill does is vacate the Tennessee Historical Commission and reconstitute the commission with a change in size and the appointing authorities for the commission from 24 gubernatorial appointees to 20 total members, with a third being appointed by the governor, a third being appointed by the Speaker of the House, and a third being appointed by the Speaker of the Senate, Lieutenant Governor. And the ex officio voting members are the governor, governor's designee, state historian, state archaeologist, commissioner of environment, and the state librarian archivist. With that explanation, I stand ready for questions.
First on the list is Representative Jones.
Thank you. To the sponsor, can you explain kind of the origin of this bill? I remember hearing about this around the Nathan Bedford Forrest debate, that they wanted to vacate the Historical Commission. And can you talk about what made you decide to vacate the Historical Commission, which has been in existence since 1919? It was established in 1919, 100 years ago, with 24 members equally divided among the 3 grand divisions of the state and appointed by the governor. What has made a change a century of precedent?
Chairman Reagan.
Thank you, Mr. Chair. The Monuments and Memorials Commission has been created. They took over part of the job of the Historical Commission. There's no need to have 52 members there when we've already separated part of that responsibility out. Additionally, the size of the previous commission was such that it was hard for them to get a quorum together.
Representative Jones.
From my understanding, thank you. From my understanding, it was 24 members on the commission, not over 50. So I just want to have the facts correct, that the Historical Commission was 24 members. And in 2020, they took the step of removing the Nathan Bedford Forrest statue after considering it for some time. And then we start hearing this debate that we want to vacate the Historical Commission. I'm just very concerned that this seems very retaliatory. And if that's not your intention, it just gives that perception. And so my concern is that we are retaliating over what they did when these are people who have volunteered to serve our state. Many of them are from historical, fields. They're people who have expertise in history. There's some diversity on this commission as well. It just seems very punitive. And I don't want us to seem like we are just responding in haste to punish people. And so can you again speak to factually, why are we vacating it? If it's not over 50 members, 24 members, why are we getting rid of this commission?
Chairman Reagan.
Thank you. And there is no criteria that prevents current members from being reappointed, so it's not retaliatory. That said, the issue here is getting a commission down to a reasonable size that can act and have a quorum present to get things done. There is nothing retaliatory about this, especially since we have, as I mentioned, separated part of their function to another commission.
Representative Jones.
Can you explain how we are making the size smaller? It seems like right now there's 24 members, and how are we making it smaller? What are we shrinking it to?
Chairman Reagan.
The bill says we're shrinking it to 20 total members.
Representative Jones.
So we're taking out 4 members, and we think that is going to make things more efficient and better by just taking out 4 people. That does the mathematics doesn't add up. You're saying that we need to make it smaller because it's too many people. They can't get a quorum, so we're making it go from 24 to 20. How does that change the efficiency of getting a quorum?
Representative Jones, he's already explained that. I need to move on. Representative Hakeem, to you, sir. I'll come back to you after Representative Hakeem.
Thank you, Mr. Chairman. Mr. Chairman, we have, I believe, the current board or commission has equal number of members from across the state, west, middle, and east. Will that same process be followed in what is being proposed to us now?
I'm sorry, can you say that, state your question again, please?
Will there be an equal number of persons from each grand division on this commission?
Chairman Reagan.
Yes, one person is appointed from each of the three grand divisions of the state, with two at-large members appointed by the Speaker of the Senate. One person from each grand division of the state, with two at-large members appointed by the Speaker of the House, and one person appointed from each grand division of the state, with two at-large members appointed by the governor. And to the question that was asked earlier, I'm sorry I did not make it clear. The ex officio members that are listed here are not counted in the 20.
Representative Keem.
I'm sorry, they are counted as 20.
Follow up, Representative Keem.
Okay, do we have clarity on the number of members? Okay. All right, thank you, Mr. Chairman.
All right, Representative Jones, back to you.
Thank you. The sponsor responded. I mean, we're shrinking this by a handful of members. It's not going to really change the makeup of the board. I mean, excuse me, it's not going to change the efficiency of the board. It is going to change the makeup of the board because we're not going to have geographic diversity. We're not going to have racial diversity. There's, you know, we're going to be getting rid of some very qualified historians. And so it's just very dangerous precedent. We know it's going to pass. We know what this is about. It's about the Confederate monuments being removed. I know people.
Point of order, Mr. Chair.
I know that people have some concerns
That's
about
extraneous.
that. But there was a process that we went through with the Historical Commission, then the Capital Commission. And so it was a very thorough process. But again, thank you so much for allowing us to share concerns about this bill.
Representative Martin,
Move the previous question.
questions being called. All in favor of moving House Bill 1375 on to Finance, Ways and Means signify by saying aye.
Aye.
Any opposition, nay?
No.
Bill moves out to Finance, Ways and Means. Next on our calendar is House Bill 1752, which is a sunset bill. Chairman Reagan, you are recognized on House Bill 1752.
Thank you, Mr. Chair. As introduced, this bill extends the Department of Corrections to June 30th, 2027, and requires the department to report back to Government Operations Committee by December 31st, 2024, to update the committee on the progress in addressing its findings set forth in the December 2023 Performance Audit Report. With that, I stand ready to answer questions.
Question for Chairman Reagan on House Bill 1752. Representative Jones.
Is anyone from the department here that we can ask questions of concerns?
Yes, sir, there is. If you folks would come forward, please. We're going to go out of session at this time. Please check your microphones, make sure they're on, and introduce yourselves for the record, please.
Frank Strata, Commissioner.
Good morning, Kim Golden, Inspector General.
Good afternoon, Linda Thomas, Assistant Commissioner.
Thank you for that introduction. Representative Jones, what would be your question?
Thank you. I had a number of concerns that were brought up recently in the audit by the comptroller about the Department of Corrections. And I just was wondering if we can get some responses from the department. My first question was, in the audit, it showed that Tennessee prisons are severely understaffed with a vacancy rate at one prison of 61%, leading to unsafe conditions for both inmates and guards. The audit also found shortage of prisoner services such as therapy, substance abuse treatment, education, and reentry assistance. Finally, there was some very serious concerns about safety because of these employment shortages, and very heinous and egregious instances of sexual assault that included housing potential predators with potential victims. Can you respond to some of these concerns that were brought up in the audit by the comptroller in regards to our prisons?
Commissioner?
Yes. So on the staffing, we have been doing a number of rapid hire events throughout our state, specifically at the Northwest facility where the vacancy rate is upwards of 60-some%. We've had a successful hiring session at that point. I think we had 26 qualifying officers at that facility. Staffing is a concern statewide. Obviously, we paid the staff at the rate that they're funded. We have hiring on bonuses. We have stipends for high security areas, geographic locations. So we do what we can to try to offset those vacancies. We do map our contraband and all of our incidents throughout our state. Honestly, as we've been mapping since May of last year, we've actually seen a decrease in the number of incidents in our state and private run facilities in the last 9 to 10 months.
Representative Jones?
I had a few questions about that, but I mean, we're also seeing a great disparity between the state-run facilities and those that were contracting with Core Civic, where state-run facilities in the fiscal year 2023 saw a 30% vacancy of corrections officers, and the Core Civic facilities saw a 42% vacancy in corrections officers. And what we're seeing is, in fact, that there are concerns, as reported recently in multiple news agencies. Every news agency is raising the alarm about what's happening in our prisons. Tennessee prisons may have also violated federal law by mishandling sexual assault cases because of these staggering staff turnover rates at Core Civic operated facilities, according to this audit of the Department of Correction. The audit also found multiple examples of the Tennessee Department of Correction and Core Civic staff violating Federal Prison Rape Elimination Act standards, including closing sexual assault investigations before receiving rape testing results. Can you respond to these concerns that we saw recently in the audit and that have also been brought to light by media reports?
Commissioner?
Yes, I could speak to the staffing, and then I'll have Ms. Golden speak to the PREA issues. For Core Civic, I will say since 2022, both South Central and Charlesdale have seen a decrease in the number of vacancies. They have spent almost $623,000 in 2023 on recruiting and advertising. Charlesdale specifically for January 2024 have seen 60 new correctional officers, and they spent nearly $200,000 in recruiting for 2023. We hold them accountable on our contract with them, and I know we find them somewhere near $20 million? $20 million. So we do hold them accountable. We look at every incident and we look at the contract performance. And I believe that we're doing the right thing as a partnership with Core Civic in our state and private facilities.
Representative Jones?
Can you respond to the instances of violating the Federal Prison Rape Elimination Act, where many of these facilities are closing sexual assault investigations before even testing these rape kits? Can you talk about and respond, why did that happen? What would lead us to do this, and what are some ways that we're rectifying that egregious violation of basic human rights?
Sure. Kim Golden, Inspector General. What's really important to note is that we didn't violate any federal PREA statute. The PREA findings as it relates to the audit were related to our own internal policies and processes. All allegations of rape and sexual abuse in our facilities are taken very seriously, and they're investigated thoroughly. In the instances where cases were closed prior to kits being received, it's important to understand the level of proof that is necessary to demonstrate whether or not a pre-allegation is substantiated in a facility. And that level of proof is preponderance of the evidence. So more likely than not, that occurred. And so as far as the facility local was concerned, that case was taken care of and it was substantiated. The criminal piece of that is where the actual kit takes place. And so those kits are submitted. DAs are consulted throughout the state to determine whether or not charges are actually going to be pressed in those cases.
Representative Jones?
So according to the audit, the Department of Correction didn't discipline or didn't document the discipline of at least 4 employees with substantiated allegations of sexual harassment against prisoners. So these are the own corrections officers sexually harassing prisoners. In response to these complaints, in response to this audit, the Tennessee Department of Correction, quote, pledged to provide, quote, training for the appropriate staff to improve compliance with federal law.
Commissioner?
Yes, that's true. I mean, in our response, we're going to do some additional training to make sure that everyone understands the process. As far as it relates to sexual harassment and those 4 instances, those individuals were coached. It was an informal coaching, and so it didn't actually make it to their personnel file as a formal coaching. But in those instances, the employees were coached to appropriate behavior.
Representative Jones?
Can you talk coaching about sexual harassment when they're in a position of power? Can you talk, what does that mean, coaching them? Is that like, is to get them to stop the behavior? We're going to coach them and say, don't sexually harass prisoners who are under your care and protection, or what does that look like?
It's more about making appropriate contact and or appropriate conversation with inmates rather than inappropriate conversations with inmates.
Final question, Representative Jones.
Thank you. I know, like many members on this committee, I mean, my office has got so many letters from people in prison, and this is something that is really troubling because these are people who don't have advocates. We can't even go to the prisons to see them. A lot of the media, we've closed the prisons to the media, and these are people who are powerless. And to see that we have instances of sexual harassment, of rape not being investigated, of seeing that we've cut programs for therapy and job opportunities and reentry education assistance. I mean, this is just, our prison system should be about rehabilitating people, not re-traumatizing people. And my fear is that because we have all these contracts with these private prisons, every one of these audits, every one of these things that I'm reading here, these core civic facilities are violating human rights of people. They're victimizing people. And we owe it to them, to do better. These are people who can't even vote. They have no voice. They have no way to hold these systems accountable, but they deserve to be treated like human beings. And what I see in this report is deeply troubling to my spirit, to my morality. And as we get these letters, I just don't know what we should do. We get letters from prisoners all the time in my office, and I don't know what we can do. And so if we can address these as serious issues and take these concerns as human rights concerns, these are human beings who made mistakes in their life and who are in detention, but still deserve to be treated with dignity. And we're seeing instances of officers not taking their harassment seriously. We're seeing people who are afraid. I got a letter recently about a man who's afraid for his life in these prisons. I mean, because of these shortages, there's no way to have oversight over them. This is our one time to plead with you to hear the voices of these people. I don't know what to do. They're not my constituents. They're in prison, but they deserve to have a voice. And that's just what I wanted to share.
Next is Representative Hakeem. Back to you, sir.
Thank you, Mr. Chairman. Commissioner, correct? All right. Just 2 points of references I want to get. Could you give us what the current rate of recidivism is within our institutions? And secondly, preparing, I'm going to say ex-offenders to re-enter society. Is there anything in regards to job preparedness that we participate in?
Yes, I'm going to turn that question over to our Assistant Commissioner, Gail Finkel, who oversees rehabilitation services.
Hi, Assistant Commissioner Gail Finkel. So the current recidivism rate is the lowest it's been in a minimum of a decade, possibly two. It's 29.4%. There are several programs that are offered across our footprint, including core civic facilities, from behavioral and substance use programs to HiSET, a literacy program, and post-secondary and vocational skills.
Representative Hakeem.
Thank you, Mr. Chairman.
Anything further? Chairman. Nope. Before Clemens, Representative McCallum.
Chairman, my question's for the sponsor. Thank you.
Okay, thank you. Representative Clemens.
Thank you, Mr. Chairman. All those wonderful programs you described happening at Core Civic, how many inmates are allowed to participate in each of those programs at one time?
It depends on how many are eligible for that. There are several programs there for core civic.
Trousdale,
Trousdale specifically.
Yep.
Trousdale has substance use. They have HiSET. They're struggling with some instructors right now, but we will be turning up the first TCAP building trades program in the next 2 months.
Representative Clemens.
And how many inmates are allowed to participate in those at one time?
I don't have that number. Each class would vary. It depends on the student-teacher ratio.
Representative Clemens.
So when I visited that facility a few years ago, after they made us wait a few hours before allowing us in the building, after they had invited us up there at any time of our choosing, they informed me that they had, I think it was a masonry room, and took me in the masonry room and loved to show that off. And it only allowed 30 some odd inmates at a time for the entire program. Does that sound about right?
I don't know factually about that number, but I will tell you that I am very familiar with the limit of students or participants in classroom and in the vocational or the hands-on lab room because of fire safety laws.
Representative Clemens?
Thank you. That was not the concern shared with me, fire safety. It was the fact that they only had so much resources and were only expending so many resources to allow that many to participate in the program at any given time. They were building brick walls, tearing them down and rebuilding them because they didn't even have the materials to do it. With inmates that are waiting for these type of credits to be even eligible for parole, having to wait, I think the waiting list at that point was over 3 years for an inmate to even participate in a program that is required by the state of Tennessee to have a chance at freedom and rehabilitation outside of the prison walls, where people are being murdered inside, drugs are being smuggled in on a daily basis based on the reports I receive. I would just reiterate the comments of my colleague. I've been up here, this is my 10th year. I can't tell you how many hundreds of letters I have received from families, from inmates, begging for help, begging for an escape and freedom from core civic institutions where the worst type of behavior is taking place. And this department has responded to my concerns. Your liaisons have helped us. We've had inmates transferred on occasion. We've had them sent to the DeBerry facility, and I appreciate that. But that should not be necessary. I don't know what type of oversight is being provided. I know there's a contract monitor, but I know the conflicts of interest that exist with them as well. We must do a better job. I beg you, on behalf of these individuals, let us never forget there are 3 prongs to this penal system: punishment, deterrence, and rehabilitation. Rehabilitation has gone by the wayside. These individuals, a majority of whom are reentering society, and we want them to be tax-paying, good, healthy citizens in our communities. It is incumbent upon us and you, with your direct oversight, to make sure this rehabilitation happens. If we're going to authorize this department and allow this to continue, I beg you, I plead with you on behalf of every community across the state of Tennessee, make sure these inmates are being rehabilitated and given a fair opportunity to re-begin their lives. Thank you, Mr. Chairman.
Any further questions for this department? Representative Jones?
Thank you. I just wanted to get a few clarifications as to the recidivism rate in public facilities versus the privatized prisons. Does anyone have a response to the difference of recidivism rates?
We don't do recidivism by facility. We do recidivism as the entity as a whole because offenders have the ability to transfer from one facility to the other. So we do it agency-wide.
Representative Jones?
Do you do by facility instances of sexual assault or rape against prisoners? Is that by facility? And can you tell the disparities between private-owned prisons versus the publicly operated prisons in Tennessee?
We do, and no disparities exist.
Representative Jones?
The news reports disagree with that, but I'll ask another question. Can you give statistics for disparities of staffing versus publicly operated facilities versus the core civic operated facilities? Is there a disparity between the private ones and the public prisons?
Linda Thomas, Assistant Commissioner. I think the commissioner at the earlier point in his speech, he indicated our highest rate of vacancies occur that's at a TDOC facility. Trousdale, I've been at Trousdale. I've been with the department since May of last year. I've been to Trousdale facility 4 or 5 times since May of last year. I can assure you that we have our eyes on Trousdale. We are engaged with the facility staff, and their staffing actually, since I've been in this department, has increased at a higher rate than some of TDOC facilities. So they're definitely increasing the staffing. I've met with their managing director. I review their rosters. I've approved their rosters. We are making progress. We recognize that there are concerns. We also have concerns. We are responsive to inmate families, the inmates. I get calls almost daily, and be assured that I do respond, as does my colleagues. So we're not sitting and not addressing issues, but I think a lot of the data that's being referenced is before. This is over a period of time, I believe, of 2 or 3 years, the comptroller's report. So I would ask that you give us an opportunity to reverse the numbers and not rely solely on what was done before we assumed our roles.
And our vacancy rates at each institution are different. They're not the same based on geographic location. Obviously, the ones out in the western part of the state have a higher vacancy rate than those here in Davidson County. So we have a different vacancy rate for staff at each location.
Thank you. Representative Johnson? We'll come back to you. Representative Johnson?
So you said Trousdale was hiring at a higher rate. Were they at a lower rate staffing wise when that started?
When I arrived, they were. I've been at Trousdale, like I said, in 2 of my visits, there were at least 50 people in each class that they had. And that has been over the last, I would say 4 months. So a total of 100 people in hiring classes that new commits that they're hiring.
It's important to know that since the pay raises of 2022, Charlesdale has seen a 25% decrease in the staff vacancies. So we are moving in the right direction. Obviously not as quickly as we would like, but it's not just in corrections. That's everywhere. There's a workforce shortage. We do everything with our partners in Core Civic as well as us in recruiting and try to retain our staff.
I think that for transparency purposes, it would be a good idea to show a difference in the core civic prisons and the state prisons and incidences there and hiring there and numbers there. It seems to me that that would be valuable information for us to have.
Thank you. Representative Jones, would you like this department, this commissioner to stop by your office and answer a lot of your questions to get the summary of what's going on now instead of what has taken place a couple of years in the past?
Thank you for the offer, but as the Government Operations Committee, this is where we can seek oversight of this department. And so I just want to make sure that we have answers on the record because the public has concerns about
yes, sir,
what's
but
happening
you're
with our prisons.
dominating time with stuff that has happened a long time ago, and they keep answering. There's changes being made, but
can I ask my question?
Please
Thank you.
continue.
Thank you. This is our only time to ask questions of this department, which we have got hundreds of letters from collectively as lawmakers. And so, and if we're clear, in 2023, fiscal year 2023, which was not a long time ago, Core Civic's 4 prisons had a turnover rate of 146%. 146%. That was just recently. And so what I'm seeking is that my question was, you stated that you fined Core Civic $20 million, that Core Civic was fined $20 million. Our state gives Core Civic $212.9 million. Can you explain what the fine was for? And do you think it was adequate to what they're being fined for?
Yes, first I'd like to address the first part of your question on the vacancy rate. They bring in TDY staff, so that's why that number seems like it's higher. They have a lot of ins and outs because they're bringing TDY staff to the facility. And also, I have said to this committee and any member of the General Assembly, and this applies to you, Representative Jones, I welcome any representative to come to any one of our prisons. I'll personally take out a tour at any facility you want, show you what we're doing in our prisons. I think the men and women are doing a fantastic job for the state of Tennessee, for the Department of Corrections, and for all Tennesseans. And I'm proud to show what they're doing. So I've offered many, many times to any representative who wants to tour, all you have to do is give me a call and we'll personally go over there together and we'll show you whatever you want and tour any of the 10 facilities inside of the state. I extend that invitation to you at any time. Now, as to the second part of your question, I'll refer that to the Inspector General.
The majority of the liquidated damages assessed are related to staffing.
Representative Jones?
Was some of the fine also because there were instances that left prisoners dead?
I'm sorry, I don't understand your question.
Representative Jones?
Some of these operational shortcomings that were brought up in these concerns that were brought up in that fine were that some prisoners died because of instances in the prison. That was a part of these findings and a part of the finding of Core Civic. Is that true? Or
I didn't see that in the report.
okay, I'll provide it to you. Again, these are concerns about our private prison system, which seems to be failing the people who are in them. And so my question to you is, do you think that it is time to switch from our contracts with these private prisons and go to an entirely publicly based prison system? Or do you think that we should continue with all these instances of disparities and concerns with Core Civic? Do you think that we should continue that contract with the concerns that were enumerated?
Yeah, as I've stated before in testimony, I feel our partnership with Core Civic is strong. We partner really well together. I think they're a value partner for the state of Tennessee. I don't believe the narrative that they're failing anything. We have issues there that we discuss with them. We meet with them. We visit the facilities, same as we do in our facilities. We do reviews after actions and take the appropriate action based on the incident. So at this time, I don't have any plans on terminating anything with Core Civic.
My last question.
Representative Jones.
My last question. I just want to say the names Christeris Allen, Laddie Coleman, and Joshua Williams, some of the prisoners who died in Core Civic facilities in 2021. Their families say that understaffing in its Core Civic's 4 Tennessee prisons are to blame for the loss of their loved ones who died in these Core Civic facilities. And so to the Inspector General who said that she didn't hear about this, I just want to say their names so you can look them up and see that these are some of the people who died in Core Civic facilities in the past couple years. And that's a failing of the system.
Thank you for being with us today, Commissioner, and your staff. And we appreciate the open invitation for all members in the House as well as the Senate that we can come visit. And one-on-one, you folks look cordial enough that you'll work with us and answer our questions if it deems necessary. Any further questions for this department? Seeing none, we go back into session. We go to Representative McCallum.
Move previous question, Chairman.
Will you remove that and let Representative Rudder make a comment before we go there, please?
Withdraw.
Representative Rudder, please.
I just wanted to end this on a positive note. Unlike my colleague from across the aisle, I have not had a lot of requests from your department to look into anything that's going on within our prison system, but I have had 2 requests. And I will say on both of those requests, I met with nothing but cooperation from your department. It was the parents of someone that was in the prison that was concerned. And both times I met with absolute graciousness. You took care of the problem, got back to me, and we were able to resolve and make the parent feel better about what was going on in the prison with their loved one.
Thank you, Representative. Back to you, Representative McCallum.
Thank you, Chairman. Previous question.
Previous question's been called. All in favor of passing out House Bill 1752 onto calendar and rules signify by saying aye.
Aye.
Any opposition, nay?
No.
The bill moves out to calendar and rules. The last item on our calendar, item number 7, House Bill 1771. Chairman Reagan, you are recognized on the bill.
Thank you, Mr.
We got a
Chair.
motion and a second.
House Bill 1771, as introduced, extends the State Energy Policy Council till June 30, 2030. With that explanation, I stand ready to answer questions.
Questions for the chairman on the bill? Seeing none, the question's been called. All in favor of moving House Bill 1771 onto calendar and rules signify by saying aye. On the opposition, nay. Bill moves out. Chairman Reagan, the gavel is yours, sir.
Thank you, Mr. Chairman. Do we have any business to come before the committee? We have a motion to adjourn, non-debatable. We are adjourned.